With the way things are going now, it seems as if Mazi Nnamdi Kanu's appeal is going to be a blockbuster. I'm serious. Like, I just stumbled upon a document, a legal brief written by a legal analyst. His name is Okezie Duruji, and he's a PhD holder. What he wrote down amazed me, was exceptional. I mean, if you carry this brief to the appeal court, if you carry this brief that he wrote like this to the appeal court, I'm telling you, OMOTOSHO will go to prison. OMOTOSHO will go to prison. This was a wonderful masterpiece, and I am going to show it to you live so that you understand that the coming days is going to be very, very eventful. I want you to watch this video to the end. Don't skip a bit, because you will see for yourself the reason why I am very, very amazed and also very, very happy. Let me read this brief for you, step by step, countering the C2C of Mazi Nnamdi Kanu's judgment in the High Court. So whatever you're doing, I advise you to leave it and focus on this video, or go and finish it up, and when you're done, you come back and watch to the end, because you don't want to miss a bit of what I'm about to reveal to you. Let's go. Now, listen to the executive summary here. On 4th November 2025, the prosecution led by Awomolo suffered a total forensic collapse. The prosecution, faced with direct, repeated, legally precise challenges from the defendants, challenges that went to the existence of the offense, the subsistence of the law, and the jurisdiction of the court, the prosecution did nothing. Nothing on that day. No reply, no counter affidavit, no oral confrontation, no identification of the governing statutes, no opposition on substance. This was not incompetence alone. It was complicity through silence. The record shows that Kanu destroyed the prosecution by forcing it to confront the law, then watching it refuse to do so. Let's go on. Number one, the prosecution's basic duty and its total failure. In any criminal trial, the prosecution has one irreducible duty, which is to identify the law creating the offense and to justify the court's jurisdiction. On 4th November 2025, Awomolo did not perform this duty, not once. Not once did he identify the exact offense creating the statute. Not once did he respond to the appeal, to the repeal, subsistence argument. Not once did he clarify which law governed the trial, which is counter section 36, subsection 12 of the CFRN. The defendants did all the legal work. The prosecution hid behind the bench. Number two, Kanu's direct challenges and Awomolo's silence. Throughout that day, Kanu repeatedly said, show me the law under which I am being tried. This challenge went to jurisdiction, required a prosecutorial response, demanded statutory clarity, record reality. Now, on the other hand, Awomolo did not answer. Awomolo did not rise to identify the statute. Awomolo did not object on legal grounds. Awomolo did not seek time to cure the defects. Instead, he said nothing and allowed OMOTOSHO to defer. Silence became strategic for them. Number three, the flagship preliminary objection met with nothing. Before 4th November 2025, Kanu had filed a flagship preliminary objection on 16th October 2025, supported by sworn affidavit evidence raising repeal and subsistence of the charging law, section 36, subsection 12 of the CFRN. Extraordinary rendition, want of jurisdiction, prosecution response. There was none. There was no counter affidavit. There was no written address. There was no oral response. There was no preliminary objection in reply. there was total prosecutorial default. Under settled law, unchallenged affidavit evidence stands admitted. Awomolo knew this. He chose silence anyway. Number 4, court-sanctioned written address. Still no response. At an earlier stage, the court sanctioned a written address specifically on the absence of any valid charge and jurisdiction. This was an extraordinary opportunity for the prosecution to 1. Cure the defects, 2. Identify the law, also defend jurisdiction. What did Awomolo do? Awomolo did nothing. He did not file a counter address. He did not confront the absence of a charge known to law. He didn't explain how jurisdiction survived. Instead, he allowed the court to defer, confuse procedure, and later abolish final address entirely. That is not advocacy. That is abdication. Number 5, Section 36, subsection 12, when the prosecution ran from the Constitution. When Justice OMOTOSHO floated the idea that Section 36 applied only at conviction stage, this was the prosecution's moment. Any competent prosecutor would have either defended that position with authority or considered that trial cannot proceed without a known defense. Awomolo did neither of them. He did not cite a case. He did not support the court's misdirection. He did not oppose Kanu's insistence on legality. Why? Because the prosecution had no answer. That was why. Number 6, extraordinary rendition. Prosecution pretended not to see it. When OMOTOSHO claimed no evidence of extraordinary rendition had been laid, the prosecution again stayed silent. This, despite the fact that rendition was pleaded on affidavit. Appellate courts had ruled on it. The Supreme Court had described it as state criminality. Awomolo did not deny the fact of rendition. He did not challenge the affidavit. He did not argue legal irrelevance. He simply benefited from judicial misdirection. Number 7, the most damaging inference the prosecution could not afford to speak. Why did Awomolo remain silent? Because any substantive response would have forced him to identify a repeal statute or admit no extant law existed or concede jurisdiction had collapsed. Silence was the only safe option for him. A prosecution that cannot speak the law has already lost. Number 8, institutional tandem, how silence and deferred worked together. What the record shows is coordination by effect, if not by design. Kanu raises law, Awomolo stays silent. Silence creates vacuum, OMOTOSHO defers. Deferral avoids collapse, trial limps forward. Final address promised, then abolished. Jurisdiction decided against Kanu anyway. This is how institutional injustice operates. The prosecutor does not argue. The judge does not decide. The accused is coerced. Number 9, public significance. This was not adversarial justice. On November 4th, 2025, there was no adversarial testing of jurisdiction, no prosecutorial engagement with legality, no defense prosecution contest. Instead, there was a judge shielding a silent prosecutor from the consequences of legal failure. That is perversion of the criminal process. Number 10, in conclusion, Mazi Nnamdi Kanu did not merely defend himself on 4th November 2025. He exposed the prosecution's emptiness, forced constitutional questions onto the record, demonstrated that the state had no law to stand on. Awomolo, SAN, responded the only way he could, by saying nothing and hoping the court would carry the burden. That hope is now frozen on the record. Written by Okezie Duruji, legal analyst. This piece is a masterpiece. 10 points, well written, analyzed, scrutinizing the discussions, the briefs, and the arguments in court, highlighting that Awomolo did nothing in court. And you know, I've always said it. Those that have been watching me throughout the court case, you will remember I always say that these mass witnesses are saying, I have nothing to say. Awomolo too has nothing to say. No argument. It's just depending on the judge. That is exactly what Okezie Duruji is saying. That Awomolo did not argue anything in that court throughout. We are here, we know. There was no argument. No, tell me, what did he argue? Throughout. Awomolo did not argue anything. I don't see any. Look at Nnamdi Kanu's lawyers. At least they tried. Nnamdi Kanu himself tried. What did Awomolo try? What exceptional brilliance did he show, did he exhibit in the court? What exceptional character, evidence, argument, dexterity did he show in court? Nothing. Nothing. It was just the judge lashing onto his silence, onto his incapability to carry out a fraud. That is what Duruji is saying. That there was no argument countering Nnamdi Kanu's, own argument or explaining loopholes that were mentioned during the case. Awomolo did nothing. And OMOTOSHO followed suit. They are together. They are birds of the same feather. They meet, they discuss, they greet. They are all friends. They planned the whole thing and executed it in OMOTOSHO's court. As simple as that. So this is exactly a wonderful brief. And this kind of brief should be considered going for the appeal. This kind of arguments can help to shape the case of Mazi Nnamdi Kanu. Well put, well exposed. This is what we need. The appeal is going to be hot, definitely, with all the people coming in, writing briefs for Nnamdi Kanu, and the one that is already written secretly for him by 6 judges already, as exposed by Masopara. That is going to be a wonderful one to see how this appeal is going to be, because he go hot for appeal court. He go hot for appeal court. The arguments choke. The argument chokes very well. Chokes very well. There is hope for Nnamdi Kanu. There is hope for Nnamdi Kanu, because as long as we are in this earth, we breathe every day, we must hope every day. It doesn't matter who is working against you. It doesn't matter. The end justifies the means. We still march on. Freedom is our destination. Till I see you next video. Peace.
OMOTOSHO, show me the law. That have been a trending music all over the world. When we said a trending, it is not all over Nigeria or Africa. I'm talking about all over the world. The pictures of Mazi Nnamdi Kanu, where it wrote, OMOTOSHO, show me the law, is trending in Thailand, is trending in Vietnam, is trending in Guangzhou, China, is trending in Macau, is trending in Cambodia, Hong Kong, and Malaysia. OMOTOSHO, show me the law. My brother, it's everywhere. This clip we just finished watching now, where our brother Chinedu explained everything in black and white. He will understand the reason why they are sending emissaries to Nnamdi Kanu to beg him to mellow down. Let me shock you. Do you know that the federal government of Nigeria is begging Mazi Nnamdi Kanu not to go to appeal court? Go and mark this in, I'm telling you now. On 26th of January 2026, on 26th of January 2026, when they schedule to rule to bring Mazi Nnamdi Kanu closer to Kuje, where he will have every chance and every right to file his appeal. My brother, that day, that case will be adjourned to March, so that Mazi Nnamdi Kanu will not have any ground again to appeal. For them to force him to sign that, what do you call it, that paper, or rather that agreement of never to agitate for Biafra again. They know what they are up to. They know that if Mazi Nnamdi Kanu is being released through appeal, either through appeal or through Supreme Court, it's a very big problem for them. So the only way they can cripple Mazi Nnamdi Kanu not to make film, even if it's going to be in the documents he's going to sign, that whatever deal we sign here, you can never go out there to broadcast it to anybody. When you do, look at your punishment. But my greatest happiness and surprise, or rather, my greatest happiness is that Mazi Nnamdi Kanu will never agree to that. Dele Momodu asked Mazi Nnamdi Kanu in one of his interviews with him, what do you think about Biafra? Are you not afraid of your life? He answered, I am dead already. That the only thing that will resurrect me is the independence of Biafra. Somebody who made such a comment, do you think there is anything, even death, no, they worry him. In fact, he don't even see death. It may sound funny, but that's the real truth. It may sound funny, but not the truth to be that. OMOTOSHO, show me the law. Even white men and women, I mean white advocates, white activists, white lawyers, the one we get a level, no be all this what they call signing now in Nigeria that don't even have a level. Lawyers will get level for this outside the shores of that zoo called Nigeria. My brother, all of them are interested on the case of Mazi Nnamdi Kanu, that make Nigeria trying everything they can to make sure that Nnamdi Kanu never appear that thing, because what they write to submit as an appeal by Mazi Nnamdi Kanu, my brother, Nigerian government will be in a very deeper mess. Even more than what they have found themselves, that Mazi Nnamdi Kanu, they will be in a deeper mess if they allow Mazi Nnamdi Kanu to appear before appeal court. Unless they are also going to buy a lawyer that will agree to do what OMOTOSHO did. Because going to appeal court now, every lawyer, every judge, every son, every prosecutor is afraid of Mazi Nnamdi Kanu's case. Do you know how many of them that recuse themselves from the case of Mazi Nnamdi Kanu from High Court? Do you know how many of them? Uncountable. Even that one said who hold the case and said, we are not going to die. We are not going to leave the case. They die on it. Rafinjani, where is that idiot again? That one don't buy go. Lawyers and judges are afraid of the case of Mazi Nnamdi Kanu because if you commit yourself, you have damaged your reputation forever. OMOTOSHO to go and apply for American visa. Even UK hand is in this thing, but OMOTOSHO to go and apply for UK visa. They will deny him the visa. That is Europe for you. That is white for you. They will help you destroy your country, and they will not allow you to enter their country. OMOTOSHO to go and apply for visa to go to Canada, Australia, all these top countries, even common UAE here, even common UAE or Japan. It is well. They have found themselves in a very, very deep, in fact, in a very, very hot soup. At the comment section, my brothers and sisters, let us continue our trend. Hashtag OMOTOSHO, show me the law. Please, continue. OMOTOSHO, show me the law. And my God must surely do something new in your life. Okay? Let us dissect the comment section. Oh, God, because that's a man going to go that. Jane Domaya said, okay, senior advocate of Nigeria, Awomolo, or Justice OMOTOSHO did not read the law very well. Their defense of carrying out a jurisdiction was broken by Nnamdi Kanu because the foundation in which they carried out their judgment was a repealed law, which both of them forgot the law. It was an embarrassment to the judiciary of Nigeria and also to Nigerian government. Ibe Steve Ibe, Oga, please try to reach the legal team and handle them the statement or send it to them. Okay? Richard Nwachukwu said, my everything must be in public concession. Chime, you don't know that he will go to prison before OMOTOSHO will go to prison. He bring Nigerians roll down that every country insulting Nigerians. I don't understand this English. Obinna Chime said, not in this country. Yaradua said, that's Yorubas, lawyers, and Yoruba judges dispensing injustice to an Igbo man. Anyway, my people, let me just end it here. This is a weekend though. Please don't drink while driving and don't drive while you are drunk. Life no get duplicate. Until I come your way again, please help me to circulate this message. My people, please follow us on all our social media handles, and as you do that, my God must surely follow you to solve all your problems. Ka Chineke mezie okwu.